Today we continue our consideration of Bill C-16, an act to amend the Canadian Human Rights Act and the Criminal Code. With this, our last day of hearings on the bill. We will move to clause-by-clause consideration tomorrow. With us today for the first hour are Jordan B. Peterson, Professor, Psychology Department of the University of Toronto, and from the D. Jared Brown Professional Corporation, D. Jared Brown, Lead Counsel. Thank you, gentlemen, for being here. You both have up to 5 minutes for opening statements, and Mr. Peterson, I believe you're going to lead off, Professor. The floor is yours.
So I think the first thing I'd like to bring up is that it's not obvious when considering a matter of this sort what level of analysis is appropriate. If you're reading any given document, you can look at the words or the phrases or the sentences or the complete document, or you can look at the broader context within which it is likely to be interpreted. And when I first encountered Bill C-16 and its surrounding policies, it seemed to me that the appropriate level of analysis was to look at the context of interpretation surrounding the bill, which is what I did when I went and scoured the Ontario Human Rights Commission web pages and examined its policies. I did that because at that point the Department of Justice had clearly indicated on their website in a link that was later taken down that Bill C-16 would be interpreted within the policy precedents already established by the Ontario Human Rights Commission. So when I looked on the website, I thought, well, there's broader issues at stake here, and I tried to outline some of those broader issues in the initial. You may or may not know I made some videos criticizing Bill C-16 and a number of the policies that surrounding it. And I think the most egregious elements of the policies are that it requires compelled speech. The Ontario Human Rights Commission explicitly states that refusing to refer to a person by their self-identified name and proper personal pronoun, which is the pronouns that I was objecting to, can be interpreted as harassment, and so that's explicitly defined in the relevant policies. So I think that's appalling, first of all, because there hasn't been a piece of legislation that requires Canadians to utter a particular form of address that has particular ideological implications before, and I think that it's a line that we shouldn't cross. Then I think that the definition of identity that's enshrined in the surrounding policies is ill-defined and poorly thought through and also incorrect. It's incorrect in that identity is not and will never be something that people define subjectively, because your identity is something that you actually have to act out in the world as a set of procedural tools, which most people learn, and I'm being technical about this, between the ages of 2 and 4. It's a fundamental human reality. It's well recognized by the relevant, say, developmental psychological authorities. And so the idea that identity is something that you define purely subjectively is an idea without status as far as I'm concerned. I also think it's unbelievably dangerous for us to move towards representing a social constructionist view of identity in our legal system. The social constructionist view insists that human identity is nothing but a consequence of socialization, and there's an inordinate amount of scientific evidence suggesting that that happens to not be the case. And so the reason that this is being instantiated into law is because the people who are promoting that sort of perspective, or at least in part because the people who are promoting that sort of perspective know perfectly well that they've lost the battle completely on scientific grounds. It's implicit in the policies of the Ontario Human Rights Commission that sexual identity, biological sex, gender identity, gender expression, sexual proclivity all vary independently, and that's simply not the case. It's not the case scientifically, it's not the case factually, and it's certainly not something that should be increasingly taught to people in high schools, elementary schools, and junior high schools, which it is, and it is being taught. I included this cartoon character that I find particularly reprehensible, aimed obviously at it as it is at children somewhere around the age of 7, that contains within it the implicit claims as a consequence of its graphic mode of expression that these elements of identity are first canonical and second independent, and neither of those happen to be the case. I think that the inclusion of gender expression in the bill is something extraordinarily peculiar, given that gender expression is not a group, and that according to the Ontario Human Rights Commission, it deals with things as mundane as how behavior and outward appearance such as dress, hair, makeup, body language, and voice, which now, as far as I can tell, open people to charges of hate crime under Bill C-16 if they dare to criticize the manner of someone's dress, which seems to me to be an entirely voluntary issue.
I'm a litigator in Toronto. I act in all manner of commercial and employment disputes. I'm not an academic. I live with my clients in the land of legal reality and how the law actually works. About 2 years ago, I began to see claims of discrimination included in every employment-related court claim. My phone now rings weekly with human rights tribunal matters. It has become a reality for employers across Canada. In August of last year, I became aware of Dr. Jordan Peterson. He was discussing what he saw as a problematic law, poorly written. That's when I observed the oddest thing happening. Lawyers, academic lawyers, important people began to say that he had the legal stuff wrong. Nothing unusual about this bill. And they also said, you don't get to go to jail if you breach a human rights tribunal order. What was happening is they weren't defending the law, but downplaying its effects. Now, as a practicing lawyer, anytime a lawyer, and particularly an academic, says, look away, there's nothing to see here, it gets my antenna way up. So I did some research, which can be found in the brief that I filed in advance of today. It sets out the path to prison on this. I knew as a commercial litigator that anyone can end up in jail if you breach a tribunal order. It is a simple civil contempt of court process. People go to jail for this. Mandating use of pronouns requires one to use words that are not their own, which imply a belief in or an agreement with a certain theory on gender. If you try to disavow that theory, you can be brought before the Human Rights Commission for misgendering, or potentially find yourself guilty of a hate crime. To sum up, on the subject of gender, we're going to have government-mandated speech.
We'll begin the questions beginning with Deputy Chair Senator Baker.
What do you have to say about the facts of what's presently in the criminal code and your reflection that somehow the genocide heading, the heading on public incitement, on willful promotion of hatred, somehow that these provisions should not be included under those headings?
Well, I'm not advocating genocide, I guess let's just say that. And my presentation here is restricted to what I see as the pronoun policy issue and the compelled speech issue.
Senator Platt.
Deliberations of this bill, and during deliberations of this bill, we keep hearing the term respect thrown around. Respect is indeed critical in debates of legislation as sensitive as this. And there are a lot of people here who need to be reminded that respect works both ways, including people at this committee. Senator Baker has already referred to comments as genocide. I don't think anybody here is promoting genocide. However, Dr. Peterson, can you comment on the notion of respect where some of your critics say, why can you not just respect your students, just use the gender-neutral pronouns? How do you respond to that?
With regards to respect is that you don't meet people, generally speaking, in a mutual display of respect. You generally meet people in a mutual display of alert neutrality, which is the appropriate way to begin an interaction with someone, because respect is something that you earn as a consequence of reciprocal interactions that are dependent on something like reputation, which is also a consequence of repeated interactions. And so the notion that addressing someone by their self-defined self-identity is necessarily an indication of basic human respect for them, I think is an entirely spurious argument, especially given that there's no evidence that moving the language in a compelled manner in this direction is going to have any beneficial effect. We're supposed to assume that just because hypothetically the intent is positive, that the outcome will be positive, and any social scientist worth his or her salt knows perfectly well that that's rarely the case. So,
Dr. Brown, you've talked about non-monetary orders that could include sanctions like orders to undertake sensitivity and anti-bias training. I would like either one or both of you to comment on whether you could explain why an individual may have a strong objection to undertaking such a training.
Well, I have a profound objection to undergoing such training. In fact, I would flatly refuse under all conditions to undergo it. Well, where's the evidence that that anti-unconscious bias training works? There's no evidence, and what little evidence there is suggests that it actually has the opposite effect, because people don't like being brought in front of a re-education committee and having their fundamental perceptions, you see, their perceptions, not even their thoughts, but their perceptions themselves, altered by collective fiat. It's an unbelievable...
There, sir. We have a very engaged committee. Concise questions and concise responses would go Senator Batters.
Thanks very much, both of you, for being here. First of all, Dr. Peterson, I want to go back to this issue of personal pronouns, and if you could please tell our committee more about this issue. It's something that I was not at all familiar with prior to this bill being introduced, and in particular about the gender-neutral pronouns and your experience in pushing back against being forced to use those gender-neutral pronouns.
Well, I don't think the people who initiated this legislation ever expected that there would be an absolute explosion of identities, first of all, and also of so-called personal pronouns, as there has been. I think Facebook now recognizes something like 71 separate gender identity categories, each of which in principle is associated with its own set of pronouns. And so it's become, well, linguistically, it's become a parody, essentially. It's become linguistically unmanageable. And it's also the case that words can't be introduced into the language by fiat. I can't even think of a time when that's actually worked. We're not exactly sure how words enter the common parlance, but it's certainly not that way. And so the legislation devolves into a kind of absurdity, as far as I can tell.
Just so everyone's clear, because I don't think these are common parlance. Z and zer, and what other sorts of gender-neutral pronouns are we discussing here?
Well, I have a very bad memory for that sort of thing, but if you're interested in it, you can find lists of them very rapidly on the web, and they've been produced by, I think, they've been produced by people whose essential desire is to gain linguistic control. That's as simply as I can put it, is to gain linguistic control. But they're not used popularly, and that seems to me to be it's a real problem as a consequence, that you make failure to make their use something that could carry a criminal penalty. So I just don't understand that, and I don't understand how the government can justify imposing a criminal penalty on the use of words that no one either knows or uses. It just seems preposterous to me, but okay. There it is.
Could you please also tell us a little bit more about your personal experience in pushing back against this? And I mean, many are familiar with your story, but not everyone, so I just want to give you a little
Well, I made a video, actually I made 3 videos, but we'll just talk about one of them. I made one criticizing Bill C-16 for the reasons that I already described, because I went and read the policies, and they made my hair stand on end to the surrounding policies. And so I made a video stating essentially that and detailed out my reasons. And you know, I've been following the battle of, let's say, ideologies on campus for a very long period of time, and I suppose I have some expertise in that. And there's an ideological war that's ripping the campuses apart, and it's essentially between an ideological variant that's rooted in what's come to be known as postmodernism, with kind of a neo-Marxist base, and modernism, I would say. And that's accounting for all the turmoil on the campuses, and I see this as an extension of this campus turmoil into the broader world, and I really believe that is the proper level of analysis. I truly believe that. And so I said that I believe that this is a vanguard issue in a kind of ideological war, and that I'm not going to participate on the side of the people whose ideological stance I find reprehensible, unforgivable and reprehensible, especially the Marxist element of it. And so I announced that I wasn't going to use these words, because I don't believe that they're instantiated to protect anyone's rights. I believe that the ideologues who are pushing this movement are using unsuspecting and sometimes complicit members of the so-called transgender community to push their ideological vanguard forward, and I firmly believe that. So I'm not participating in that. And the fact that it's potentially illegal for me not to participate in that is something that I regard as, I think that's absolutely dreadful. It puts a shudder in my heart as a Canadian that we could even possibly be in a situation like that.
Senator Gold.
The issue is the pronoun, and unless I'm reading it wrong, as Senator Pratt pointed out, the Ontario Human Rights Commission policy does not say that refusing to use a person's self-identified name or personal pronoun does constitute gender-based harassment. I may be wrong, but I believe it said it could. And I think that's a real difference. If I turn to you and say, look, please call me they, because that's how I see myself now, because it's hurtful for you to call me sir or miss, whatever it would be, but you refuse. And I say, well, okay, if you're uncomfortable with that because you're not comfortable with that, call me Mark. And you refuse. Were you to continue to call me by the name that I'm telling you is hurtful to me, is that not, in fact, something that that the law can properly address? This is, you are knowingly hurting me. And in that respect, our courts ultimately, I think, are capable of striking a proper balance between people who slip up or who, for whatever reasons, just can't get the words out of their mouth, and those that persist in intentionally causing harm.
Opportunity to respond.
Would you agree with my characterization of free speech as it applies to these issues?
Let me jump in just on the legal point.
Thank you.
After Dr. Peterson posted his videos and after he rose to the public consciousness, the Ontario Human Rights Commission deemed it fit to release a new policy document called Questions and Answers about Gender Identity and Pronouns. And in so doing, they said that refusing to refer to a trans person by their chosen name and a personal pronoun that matches their gender identity or purposely misgendering will likely be discrimination. So I think it's a little bit more certain than what you may have indicated in your comment.
Well, so I would say that the very idea that calling someone a term that they didn't choose causes them such irreparable harm that legal remedies should be sought, rather than regarding it as a form of impoliteness, that legal remedies should be sought, including potential violation of the hate speech codes, is an indication of just how deeply the culture of victimization has sunk into our society.
Just one more. Again, Mr. Barron, you spoke about the chilling effects of overly broad legislation. I'm wondering if you consider the terms gender identity and gender expression to be equally broad, or do you consider one broader than the other?
The courts don't like overbroad terms, and I would refer you to the decision of London Boisson of the Alberta Court of Appeal, where in that case the Court of Appeal says the objective of statutory interpretation is to discern the legislative intent from the language of the legislation, if possible, and to give effect to such intent. This objective becomes difficult to attain where there is conflict, imprecision, or a lack of clarity in the legislation. Of particular concern in the area of human rights law is that a lack of clarity will cast a chill on the exercise of the fundamental freedoms, such as freedom of expression and religion. And so, while I personally believe that the terms are not properly or not clearly defined and somewhat ambiguous, the courts don't like that type of legislation either.
Just to add two things. With regards to the chill, it's already the case, and I've seen this among my own students when they're teaching personality, which is what I teach, which also involves assessment of gender differences between men and women, that the proclivity now is for the advanced PhD students to avoid any such discussions in their classrooms because the potential cost of transgressing against an unknown norm, let's say, is so high that it's just easier to teach other things. And so I've seen that clearly and with multiple people. And I would also say that it's no trivial matter that the Department of Justice's link to the Ontario Human Rights Commission and their statements about how this legislation was going to be interpreted mysteriously disappeared in the middle of December. Of all the things that have happened to me, happened in relationship to this that I've been studying, I think that was the most chilling. It's like, because it was the, what would you say? It was the smoking pistol, right? Because the issue is, what's the right level of analysis? Are you just supposed to look at the legislation? Well, since the Justice Department said, no, you're supposed to look at the surrounding policies, well, that's what I did, and that's what I based my case on. And then all of a sudden, the link to those, the link tying those two things together just vanished, and people had to go into the Internet archives to fish it back out so that it could remain part of the public record. I think that's absolutely scandalous.
Thank you, Senator Ahmedvar.
Thank you, Chair, and thank you both of you for being here. I was trying to take notes, but I think I got this right, Mr. Peterson, that you talked about this bill as being an expression of the vanguard of ideology. Am I right in thinking?
Well, I was thinking more about the policies that surrounded it, but
Okay.
yes.
Yeah. So I'm trying to square what you, as a party of one, are saying with published documents from the Canadian Psychological Association, the American Psychological Association, the Canadian Medical Association, the American Psychiatric Association, the Canadian Psychiatric Association, and the United Nations human rights experts. So these are all, these are not parties of one. They are associated. They are all, I imagine, lots of psychologists are members of the Canadian Psychology Association and the Canadian Psychiatrists. So how are we to square what you're saying, which is your opinion, which you are absolutely entitled to, with what everyone is saying, plus the feelings and testimonies of the people who have suffered over 30 years, who've been taking issues to court? These are people who we've listened to. So how are we to square this?
Okay, well, with regards to your second point, if the people that you're listening to aren't randomly selected from a population, then their opinions are worthless from the perspective of testimony, because you don't know if you're dealing with a biased sample. And that's a big problem with the public consultation process that underlied this bill. And you can not appreciate that if you'd like, but it's standard practice in any polling institution or any body that's attempting to extract a genuine opinion out of a so-called community of people. And if that isn't followed, then you can't tell if the information that you're receiving is biased. And this, with regards to your first point, what exactly are all those people who aren't thinking the same way as me saying? You said that there's a bunch of them and a bunch of groups, but you never said what they're saying precisely.
Well, I think our chair would rule me out of order if I proceeded.
No, you're fine.
To read out what they're all saying. But in general, they say they oppose discrimination and harassment because of gender identity and gender expression. And then there's 3 pages, which I can share with you.
I oppose discrimination against gender identity and gender expression. That's not the point. The point is the specifics of the legislation that surrounds it and the insistence that people will have to use compelled speech. That's what I'm objecting to. I've dealt with all sorts of people in my life, people who don't fit in all sorts of different ways. I'm not a discriminatory person. There's 500 hours of my teaching to my classrooms on tape on YouTube, and nobody's found a smoking pistol. I'm not a discriminatory individual, but I think this legislation is reprehensible, and I do not believe for a moment that it will do what it intends to do. I also don't think that my opinion deviates substantially from the bodies that you're describing, because you haven't provided any evidence that they say anything other than discrimination is a bad thing. And I think that unreasonable discrimination is a bad thing. And it's unreasonable when people are judged for any reason other than the specific competence that they bring to, say, a given position. It's not in anyone's best interest that that occurs. But I don't think that you've demonstrated in the least that the opinions that I'm putting forward exist in opposition to the standard practices, say, of my particular discipline. So,
Dr. Peterson, I'm trying to understand your position. Do you see a difference between the opinions that you are expressing today on this issue as part of this public consultation, and the actions that you take as a university professor, where you are in a position of authority and power over your students?
well, first of all, I don't necessarily consider myself in a position of authority and power. I consider myself in a position of responsibility. And those aren't the same thing. So I don't agree with the way that the question is formulated. And I don't understand what that has to do with my stance. I mean, if I believe that the legislation is going to do more harm than good, and I also firmly believe, which I do, that it is more in the issue of an ideological move. But I put my finger on something. That's what I thought. And the fact that this issue hasn't gone away in 9 months, quite the contrary. It's exploded, not only in Canada, but in all sorts of parts of the world, means to me that I have some evidence that my choice of level of analysis was correct, and that there's far more going on here, so to speak, than the mere surface issue that we're purporting to discuss. And so I take exception to the notion that I'm somehow abandoning my personal responsibility to my students, which is something that I believe is in fact driving what I'm doing. I believe that my obligation to my students constantly is to tell them what I think and to make that as informed and careful an opinion as I can possibly master, and that's what I do.
I think that you understand that if you come to participate or to appear before a Senate committee studying a bill, regardless of what we think of the question, that, I mean, my question for you is, do you make a difference between your opinion, what you say, and the fact that the university, which pays you, I believe, unless I'm wrong, the university considers you to be under its legal responsibility, and so you are in a situation of authority over your students. And this means that you can give an A or an F to your students.
And the components of the legislation, I think that's relevant. I'm going to move on. Senator McDonald.
Thank you, Chair. Dr. Peterson, I have a question for you. The thing that concerns me most in this legislation is compelled speech. I think that's very concerning. This committee has heard from Megan Murphy, who told us her opposition to this concept of gender fluidity because she believes gender is a social construction. And Dr. Gad Saad also opposed to this legislation because of his belief in evolutionary biology. What this shows is that with Bill C-16, we are prematurely shutting down a discussion on gender and sex that is far from settled, or appears to be far from settled. And in my opinion, when we look to the provincial definitions set up by the commissions, we are enshrining the theory of a gender spectrum into the law. I wonder if you can comment on that.
That's exactly what we're doing. And I think that might even be more dangerous than, in my opinion, than the compelled speech issue, because the social constructionist view of gender isn't another opinion; it's just wrong. So, because, and I can tell you why that is fairly. I'll take 1 minute to do that.
Please.
Well, the proposition that's instantiated, for example, in this particular visual, which is a good representation of the philosophy of the policies, is that there's no causal relationship between these four dimensions of identity, and that's palpably absurd. I mean, 98% of people. It's 99.7% of people who inhabit a body with a given biological sex identify with that biological sex. They're incredibly tightly linked. If you can't attribute causality to a link that's that tight, you have to dispense with the notion of causality altogether. And then of the people who identify, say, as male or female, who are also biologically male or female, the vast majority of them have the sexual preference that would go along with that, and the gender identity, and the gender expression. These levels of analysis are unbelievably tightly linked, and the evidence that biological factors play a role in determining gender identity is, in a word, overwhelming. There isn't a serious scientist alive who would dispute that. Now, you get disputes about it, but they always stem essentially from the humanities. And as far as I'm concerned, I've looked at it very carefully. Those arguments are entirely ideologically driven. It's a tenet of the ideology that identity is socially constructed. And that's partly why it's been instantiated into law, because there's no way they're going to win the argument. But they can certainly win, let's say, the propaganda war, especially by foisting this sort of reprehensible advertising information on children, and that's part of the express intent. If it's mutable, changeable, only subjective and transformable on a whim, then why should anyone have any respect for it?
Gentlemen, I'm going to have to intervene. The hour has flown by, and we all very much appreciate your appearance here today and your testimony as well. Thank you. We'll suspend briefly before hearing from our next witnesses.